Begin the recording and also call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Commissioner of Labor, State of Vermont versus American Empire General Contracting Corporation. Case number 24 AP 207. Appellant American Empire General Contracting Corporation is self-represented by Brian Horton. Representing the appellee, Commissioner of Labor, State of Vermont, is attorney Rebecca Landon Smith.
Thank you very much, and good morning, everybody. Mr. Horton, can you hear me?
Yes, sir.
Okay, and we can hear you. You understand you have 5 minutes. We'll try to give you an alert when your time is short. Please start by introducing yourself for the record and then proceed.
My name is Brian Horton, Horton, and I'm one of the former owners of American Empire General Contracting.
Thank you very much. Please go ahead.
I'm going to start my timer. Okay, the reason we are here, obviously you have the appeal, the briefs and the reprise, so I won't reiterate what's in there. But the reason we're here is we're appealing a Washington unit grant of summary judgment. And the problem is we don't have to, since it's de novo review, we do not have to go and figure out what kind of mistakes the lower court made, because all we got to do is look at the record. And the primary problem with this case is jurisdiction. And I have presented the jurisdiction argument to the Department of Labor from the first day I was ever contacted. And this jurisdiction issue has never been addressed. I will repeat, it has never been addressed. We went through the ALJ process. It was not addressed. I appealed. It was a procedural issue with dates. It went to the Labor Board. It went to the Supreme Court, and the jurisdiction was never addressed. I addressed it in my reply to the summary judgment, and a court of competent jurisdiction has never addressed whether the DOJ has jurisdiction to hear this case and make a determination.
Isn't the fact that you didn't appeal it on time? I mean, you're kind of getting to the merits of a decision below that you didn't appeal on time. So how do we even get to that issue?
Well, I did appeal on time for this motion of summary judgment.
But I mean, appeal the ultimate decision below.
Oh, from the ALJ?
Yeah.
Well, what happened was the ALJ, the Department of Labor, extended my deadline. We had 3 separate deadlines for appeal date, and the ALJ overrode the DOJ's extension and said no, there was a proper service on the second date. And that's what I appealed. I did appeal. I went to the Labor Board and I went to the Supreme Court, and everyone in the food chain said no, we're going to go with the second date, even though I had an extension that there were 3 dates. So now they want to enforce their determination through the Washington unit. And the Washington unit did not address the jurisdiction. So that's why we're here. We're back to full circle. And if a claimant can manufacture evidence and make misrepresentations to get the DOJ to assume jurisdiction over a case that has never been heard, that's what I'm asking for. I'm asking for one hearing on the jurisdiction, on the merits of whether the state of Vermont even has the jurisdiction to deal with this issue. And that has never happened. If you look at the record, I've got the jurisdiction argument in there, and it's all based on misrepresentation by the claimant. And the DOJ has never picked up that. They've never picked that up and dealt with the jurisdiction. And I'm going to reserve 1 minute for rebuttal.
All right. Okay. Thank you very much. We'll turn to counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Yes. Good morning, Chief Justice Reiber, Associate Justices, and Mr. Horton. We've spoken a number of times, but it's good to finally get a chance to see you. May it please the court, I'm Rebecca Landon Smith. I'm representing the appellee in this matter, the Commissioner of the Vermont Department of Labor. And Your Honors, this is a case about finality and about compliance with judicial orders. This court should confirm the summary judgment order issued by the Washington Superior Court because the appellant employer's opposition is an impermissible collateral attack on a final order. The present case, as Mr. Horton has mentioned, involves the exact same parties and the exact same matters that were addressed by this court a year and a half ago. It's 23 AP 145. And since it's the second time that we've come before this court, I don't intend to reiterate any of the details, which are amply addressed in the record, unless there are any questions. As a result of this court's previous review, the Department of Labor now has a final order for payment of wages. Our operational statute in Title 21 directs the commissioner to enforce that order in the civil division of the Superior Court. The commissioner did so, and it's the court's order in that enforcement action that's being appealed here. The enforcement stage, I believe the issues are very narrow at that point. Is there a final order that's ripe for enforcement? And if so, what is the amount due thereunder? I think Justice Carroll was right on point in indicating that, or questioning whether issues of jurisdiction over the subject matter of the case or over the parties involved, whether that was waived by the failure to appeal. We believe this court found that they had been in its previous decision. We agree with that. And so the result is that there is a final order. The department, as far as the summary judgment went, we proved our entitlement by sworn statement, citation to the record. And in contrast, the appellant employer provided narrative opposition to the Superior Court, lacking in any evidentiary support. The employer's opposition was based on the lack of jurisdiction and misrepresentations occurring at the administrative stage of proceedings. And I will take issue with one thing that Mr. Horton said about jurisdiction never having been considered or reviewed. The very first determination by the wage and hour program that resulted in the issuance of the determination and order for collection did in fact consider and discuss whether jurisdiction existed, found that it did. That order was then determined to be a final order by the administrative law judge, and as we know, upheld by the security board, affirmed by this court. So the Superior Court, in its deliberations, correctly recognized that the employer's argument was an impermissible collateral attack on this court's 2023 order in 23 AP 145. And as we know, it's been thoroughly discussed, I think most recently in the Second Slate Ridge case of last year, the importance of barring collateral attacks. It's essential to the stability of court decisions, to a functioning judicial system, and that he, in this instance, the appellant employer, should not have an opportunity to belatedly relitigate matters that have already been made final.
You have 1 minute, counsel.
Thank you, Chief. So I would just say that accordingly, the Supreme Court's summary judgment order was properly issued, should be affirmed by this court, and I would be happy to address any questions that the court might have.
All right. Okay, I don't see any hands, so we'll turn back to the appellant. How much time does the appellant have, please?
One has 53 seconds remaining.
Mr. Horton?
Yes, Your Honor.
You've
Yeah.
got almost a minute. Go ahead, please.
Okay, so collateral attack on a final order, that is permissible, and especially under the context of jurisdiction. There's a case that's OCS Glenn's Pappas, and even in the case where another state had made a final there was a final decision from another state. The state of Vermont was required from the Constitution to give full faith and credit to that decision. The Vermont Supreme Court said, we have to look at the jurisdiction issue. And if that jurisdiction was not finalized and it was not adjudicated in the original case, the state of Vermont can second guess that full faith and credit of the other state's determination. That's OCS Glenn's Pappas. And it's very strong because it's saying that if there's an issue of jurisdiction, which is also part of the administrative rules of procedure after a case has been decided, this is always an issue. Was there jurisdiction to begin with? So
Okay.
it's never been determined.
All right. Thank you very much. Your time has expired. Please